So it's
Okay.
recording.
Okay. Welcome to our Chinese Canadian RCIC WeChat group, the 14th online non-CPT seminar. Yeah, welcome to our speech guest, Stephen Tress. Yeah, we have the privilege of delivering into vast experience of Stephen Tress, a Canadian lawyer practicing immigration and criminal defense law. With over 3 decades of dedicated practice, he brings comprehensive expertise as both an immigration and criminal defense lawyer throughout his career. He has successfully navigated complex immigration and citizenship applications, advocated for clients in immigration tribunals, and litigated judicial reviews at the Federal Court of Canada. And yeah, let's warmly welcome Mr. Stephen Tress to our non-CPT seminar. And thanks for your time and knowledgeable advice.
Well, thank you for your very warm welcome. I'm honored to be here, and it's a pleasure to be here, and thank you for the invitation.
Yeah, thank you. Can you share your views on intersection of criminal and immigration law in Canada based on your knowledgeable and experience in this field? And why is it important for everyone to know about this?
Sure, I'm happy to answer any questions that you might have or the participants might have. It is a sort of specialized area where the two areas of practice intersect, and it's been the focus of my practice, and I'm happy to answer any questions that you may have.
Okay, let me just mute myself, and anytime you need me, just let me know.
Okay, so I do get a lot of questions from various practitioners, whether they are criminal lawyers, immigration consultants, or even paralegals who practice criminal law, who do summary conviction cases. And one of the questions I get is, how do criminal convictions impact an individual's immigration status or even their ability to apply for citizenship? And there's no short answer, but as you all know, we have an inadmissibility section in the Immigration and Refugee Protection Act, affectionately known as IRPA, and the inadmissibility sections really start from section 34, and they go up to section 37. But the most commonly used one are section 36. And section 36 applies to either criminal convictions or criminal charges or criminal commission of offenses that are, if they're committed outside, are equivalent to an offense here in Canada. And it could affect a person's status in Canada, whether they're a permanent resident or a foreign national. And in terms of citizenship, any conviction or probation period could either delay or prohibit an application for citizenship. And there's some more participants that I'll let in. So one of the other questions that I get, another question I get is, just pull that up here. What are the key challenges faced by individuals navigating both the criminal justice and immigration system simultaneously? So I suppose the most common example is when someone is here, either on a study permit or on a permanent resident status, and they are charged with a criminal offense. And as you know, there are two types of criminal inadmissibility. One is criminality, and the other is serious criminality. And criminality applies to foreign nationals. So anyone who's here, for example, on a study permit or a work permit or visitor status, or someone who wants to enter Canada to obtain one form of temporary resident status or another, that's regular criminality. We call it regular. It's just criminality, and serious criminality deals with the status of both foreign nationals and permanent residents. And normally, when someone gets charged, they are represented by a criminal lawyer or maybe a paralegal. And the criminal lawyer and paralegal cannot advise the client on the impact of immigration on their immigration status. And it's important because, according to some Supreme Court of Canada decisions, a criminal lawyer must refer a client for independent legal advice if they're not competent to advise the client on their immigration status. So they would need to be referred to either an immigration lawyer or an immigration consultant, of course, could advise them on that. And that must be done before any plea, for example, or any course of action is taken. So sometimes the Crown Attorney will propose a deal. And before that criminal lawyer recommends the deal to the client has to get advice from an immigration practitioner as to what the consequences would be. And this is important because in order for the plea, a guilty plea, to be informed, the client has to know the total impact of that guilty plea. I'm just letting a few more people in. Another question that comes up is, how do immigration policies and enforcement practices intersect with criminal justice policies and practices? And I suppose, hello, somebody can mute themselves, please. So one of the issues that comes up on that particular question is when someone is under a removal order, and they are also going through the criminal justice system at the same time. They maybe set a trial date for next year. However, CBSA has an obligation to remove someone as quickly as practicable. However, in most cases, when there are pending criminal charges, there can be a deferral of removal request. And immigration almost always grants the deferral request, except for one notable exception. Sometimes the CBSA and the Crown Attorney make a deal where if the CBSA removes the person, then the Crown will stay the charges or withdraw the charges. So sometimes there is that result. But if the Crown is not willing to stay the charges or withdraw the charges and insists on continuing, then deferral request would normally be granted to allow the person to remain in Canada. So moving on to next question. What are the potential consequences for non-citizen defendants in criminal proceedings, particularly regarding deportation or removal? So as most of you know, Section 36, for example, provides that a foreign national or a permanent resident, for example, I'm dealing with Section 36(1), is inadmissible to Canada if they've been convicted of an offense in Canada where the punishment is 10 years or more, or where the actual sentence is 6 months or more. And if they are convicted outside of Canada, then it must be equated with a Canadian offense that has those criteria, that's punishable by at least 10 years or more. It doesn't matter what the sentence is outside of Canada. And another circumstance is where someone has either been charged with an offense, maybe it's been dropped, maybe it's been dismissed, maybe they got a conditional discharge, maybe they were even acquitted. However, Canada Immigration can still do their own assessment as to whether or not they committed an offense, and the standard of proof is much lower under IRPA than it is in most jurisdictions, and certainly lower than in Canada. So those are potential inadmissibility issues to look out for. Then another question that comes up is, what legal rights do immigrants have when facing criminal charges, and how do these rights differ from those of citizens? So this question comes up, and I think most of you know partially the answer. Canadian citizens, of course, cannot get deported for criminal convictions. So it really only affects non-citizens. And a permanent resident, depending on the length of sentence, a permanent resident does normally have a right to appeal to the IAD. So let's say, for example, a permanent resident gets convicted in Canada and drug offense, and it's an indictable offense, and the Crown proceeds by indictment or summary conviction. Doesn't matter because, of course, Section 36 says it doesn't matter. The person receives a 2-year conditional discharge. So there is a Supreme Court of Canada case that came out in 2017, which basically changed the interpretation of what a conditional discharge is. Prior to that, a conditional conditional sentence. Prior to that, a conditional sentence was a form of imprisonment. And if the conditional sentence was more than 6 months, then they would be inadmissible and they would not have a right to go to the IAD. However, I believe the decision was Tran. It was in October of 2017, which held that conditional sentence, which is like house arrest, does not count as imprisonment under IRPA. And therefore, there would be no barrier to go to the IAD where you can argue humanitarian and compassionate grounds. Another question that comes up is, what strategies can lawyers employ to effectively represent clients dealing with both criminal and immigration issues? So let's talk about how you might be involved, for example, as an immigration consultant. So criminal lawyer, for example, has a client who's charged with an offense, and the Crown was offered a deal. But either the criminal lawyer already knows that pretty much destroys the immigration status of the individual if they take the deal, or they're not sure. But either way, they would refer the client to independent legal advice, and the client would be advised of the immigration consequences, and that would normally be shared with the criminal lawyer. But in addition to that, because of another decision of the Supreme Court of Canada, I think it was Nguyen, the Crown and the court, the criminal court, has to take into account the immigration consequences when dealing with a foreign national or a permanent resident in the criminal justice section. So I'll give you an example, and this is something common that I get contacted by my criminal lawyer colleagues. A person is charged with impaired driving, any of the impaired driving provisions, whether it's blowing 80 or more milligrams in 100 milliliters of blood, or just driving while your ability to drive is impaired by alcohol or a drug. And in Ontario, and probably most of Canada, a conditional discharge, which is not a conviction, would not affect a person's immigration status on a charge like this, except that in Ontario and most provinces, Crown attorneys have specific instructions that conditional discharges are not available. So what do you do? And so normally I get contacted by a criminal lawyer, and they say, can you issue a letter of opinion, which details and quotes sections in case law and regulations, and shows that if a person takes the deal, then they'll be issued a removal order. And there may or may not be any chance at the IAD, but that's in the future. So I prepare something like that, send it to the criminal lawyer, then the criminal lawyer sends it to the Crown and tries to swap out the charge. So in other words, a person is charged with what we Americans call DUI, and maybe the criminal lawyer can persuade the Crown to swap out that charge with a charge of dangerous driving, for example, under the criminal code. Now, dangerous driving does, if a person's convicted of dangerous driving, the maximum sentence is 10 years. So they can still be inadmissible. However, there is a conditional discharge available for dangerous driving. So even though a conditional discharge is not available for impaired driving, if the Crown agrees to swap the charge and lay a charge for dangerous driving, and then a joint submission on a guilty plea to that charge for a conditional discharge, then then that wouldn't have any effect on a person's immigration status. So that's one use where an experienced immigration consultant on criminality can write a letter of opinion or contact a colleague of yours that has the experience in writing letters of opinion. That would be helpful to criminal lawyers negotiating with the Crown. And let's say, for example, just as a side example, let's say it's not impaired driving. Let's say the Crown originally charged the client with dangerous driving, but is not agreeing to a conditional discharge. They're agreeing to maybe a suspended sentence or something. There is a potential for that same letter of opinion, even if the Crown doesn't go along with it, to be used on sentencing, because a criminal lawyer can always make a submission that the person can be granted a conditional discharge, even if the Crown is looking for a conviction. And that letter of opinion must be considered by the judge in assessing whether or not a conditional discharge is appropriate in all the circumstances. So this is the impact of how immigration consequences can not only influence a decision of the Crown, but also the judgment of a judge on sentencing. So that can be very useful. What strategies can lawyers employ to effectively represent clients dealing with both criminal and immigration issues? So from RCIC's perspective, you can team up with a criminal lawyer to try to see what result would be both beneficial on the criminal lawyer side and on the immigration side of things. Another question I get is, how do changes in immigration law or criminal justice policies impact individuals at the intersection of these two legal domains? Well, yeah, quite a bit. One sad situation that arose for clients before the Tran decision, and I just had a consultation yesterday, or maybe it was last Friday, where a client was convicted of an offense and given a conditional sentence, which you talked about earlier, which is a conviction, but it's house arrest. And the issue was whether or not the client could go to the IAD. And so the immigration consultant representing the client filed an appeal with the IAD after the client received a removal order at the immigration division. And the IAD dismissed it for lack of jurisdiction, because at that time, a conditional sentence was considered imprisonment, and the client got 2-year conditional sentence, which means 2 years, which means they can't go to the IAD. And then 2 months later, the Tran decision came down, which is why I remember the date, because of the consultation I had. The Tran decision came down and said, no, you can go to the IAD with a conditional sentence. Unfortunately, it was too late for those cases that were already dismissed. There is no mechanism to reopen the case at the IAD in those circumstances. So there's one way where a change in law helps a certain group of clients going forward, but not necessarily retroactively. So it's always important to keep these changes, to keep track of these changes, to keep up with the latest developments of the courts, just to see how the interpretation of the Immigration and Refugee Protection Act is currently viewed from the federal court or the Supreme Court of Canada. Another question is, what are some common misconceptions or misunderstandings about intersection of criminal and immigration law? All right, so, well, this raises an interesting issue. So I was contacted by a client after he was convicted. Sorry, he wasn't convicted. He was given a conditional discharge, but CBSA was still going after him. So I took a look at everything. And so what happened is that this particular client was charged with robbery with 2 co-accused. So 3 individuals broke into a Leon store or something, and then they subsequently got arrested, and then they got charged. And the criminal lawyer, so the Crown, was offering to this particular client, wasn't my client because I just met the client after the fact, but the Crown attorney was offering the client that if he pleads guilty to robbery, he'll get, they'll do a joint submission for a conditional discharge. And the criminal lawyer referred the client to, I don't know if it was an immigration lawyer or immigration consultant, but just basically said, if it's a conditional discharge, there's no problem. So during a guilty plea, the Crown Attorney reads out an agreed statement of facts, which is usually just the synopsis that the police prepare at the beginning. It can be changed, but the agreed statement of facts was read in by the Crown. There was a finding of guilt, and the judge granted a conditional discharge. So then the CBSA went after him, not under Section 36, but under the organized criminality, it might be Section 35, I think, organized criminality provision. So in other words, a person is inadmissible to Canada if they belong to a criminal organization, and a criminal organization is defined as 3 or more people who are working together to commit criminal offenses such as robberies. And the way that the facts were read in by the Crown suggested that the client, in concert with 2 co-accused, which forms an organization, has committed a series of robberies. And even though the client was given a conditional discharge, CBSA can still go after the client for organized criminality. And even if the client is found not guilty or is acquitted or the charge is withdrawn, CBSA can still go after the client for organized criminality because the burden of proof is much lower under IRPA. It's reasonable grounds to believe. It's not proof beyond a reasonable doubt. And in this particular case, in the consultation I had, is that the client pled guilty, was given a conditional discharge, and then he was brought up before the CBSA. Now, there wasn't much I could do at that point. Well, there was. In that particular case, it was my view that the client was not fully informed of all the potential immigration consequences. And so that the remedy there would be to go to the Court of Appeal on the criminal matter and have the guilty plea vacated because it wasn't an informed decision. The client wasn't properly advised. But the reason I'm raising this story is because let's say you get contacted by a criminal lawyer. The one thing you should do is ask to see a copy of the synopsis that is going to be read in by the Crown, because a criminal lawyer can negotiate with the Crown on a guilty plea. Okay, we're not going to tell the whole story in court. We're just going to tell part of it. The client's going to plead guilty to that part. And so you can fashion the agreed statement of facts or the Crown synopsis so that if the client is given a conditional discharge, it won't impact on other sections of the Immigration and Refugee Protection Act. So I know these are complex situations, and I see there's a question, and I don't mind being interrupted. So we have Ivory X raving. Did you have a question?
Hi, yes, thank you for the, sorry, I don't have the chat function, just gonna ask a question. I actually have a couple of questions, if I may.
Sure.
So the first question is concerning just taking the example of the Tran case you mentioned. So for example, for the DUI, which occurred, to my best recollection, sometime around 2018. Take example, if somebody had a DUI offense.
December 18th.
Oh yeah, December, thank you. So prior to the new rules,
right.
But the sentence happened after the new law kicked in. So what is that point that you're going to take to decide this person would it be falling under Section 31?
Okay, so there is a case called Nguyen, which actually deals with those kinds of scenarios. In general, and you'll have to check the jurisprudence on that. But in general, an argument can be made that's consistent with the Nguyen decision that the social contract between Canadian society and the permanent resident or the foreign national, the social contract as it existed at the time that the offense was committed is the one that should be applied. All right. So in other words, it would be unfair to punish someone after they committed the offense. So if my understanding is correct, and again, I encourage you to check that Supreme Court of Canada decision, the lock-in date is the date that the offense was committed, not the date of conviction or the date of sentencing.
Okay, thank you.
Right?
My second.
You got to do your own research, though, right? You don't.
Sorry, a quick reminder that Stephen, can you just admit some other people to enter into the meeting room?
Sure. Actually,
Yes, thank you.
what time is it? So two. Yeah. Why don't we take a break for 5 minutes, washroom break,
Oh.
and I'll give other people a chance to sign on.
Okay.
Okay. So I'm going.
Other people can,
Yeah,
continue to ask questions.
Oh,
I think
okay.
Ivory still has questions to ask.
Yeah, that's fine.
Emma, is it
Should I go
possible,
ahead or?
is it
sorry.
possible for you to enable the chat box function so everybody can ask the questions? just
I
by-
don't have that feature available on my Zoom account. Sorry.
I don't know
it's
why,
fine. Oh,
yeah.
I'm
And
sorry.
I'd rather questions be asked as
Yeah.
part of the meeting, not on
People
the
want
side.
to ask questions, just click the button, raise your hand. So
Okay,
you
wonderful.
can
Thank
open
you.
your, unmute. So you can talk with Stephen
I'm
later.
not, if it were enabled, I wouldn't be reading them. I'd be focusing on the questions asked during the meeting anyway. So feel free to raise your hand.
Thank
Now,
you.
did somebody else have we have another hand raised, or did Ivy finish? Did that answer your question?
Yeah, I did. Thank you. I do have a second question, if you don't mind.
That's what I'm for.
Okay, thank you. So there's a situation sometimes when we have consultation with a client, they would share with us incident where they had, for instance, physically attacked somebody or made a threat. Well, that's an act. There was no criminal consequences. There was no charge. There was no conviction whatsoever. But this information came to your.
Was the act inside of Canada or outside?
Could be inside or outside Canada. People don't report it to police sometimes. They just let it go. But during the consultation, this became knowledge to you. And technically, under the section of the ERPA, there's C, I think subsection 31C or 2C, where if there's a commitment of an act which potentially could constitute an offense, well, how do you deal with it? Do you then file rehabilitation? How do you deal with it?
Firstly, paragraph C in subsection 1 and 2 only deals with acts committed outside of Canada. Okay.
Oh yeah, you're right.
Right. Okay. And that is an interesting question because paragraph C can apply even if they were found not guilty in their home country. Okay. Or even if the Crown, the prosecutor dropped the charge. I mean, even if they were acquitted, because CBSA and a board member at an admissibility hearing can make their own findings on the and the standard is reasonable grounds to believe. So, which is a much lower standard. So if they're acquitted, if they're found not guilty because the prosecutor failed to prove beyond a reasonable doubt, that doesn't foreclose a board member at the immigration division during an admissibility hearing to find that there still is reasonable grounds to believe that the person committed the offense. So if there are a couple things, and it depends on the scenario. If the person has already been deported after an admissibility hearing, then sure, rehabilitation, you have to go from the date of the commission of the offense. You have to do the 5-year calculation. If the person was, if the person is still outside of Canada, maybe they're applying for a visa and this came up, whether it's a TRV visa or a PR visa, then perhaps an argument could be made by an expert who can argue that the foreign statute is not equivalent to the Canadian statute, or that the acts committed do not fit squarely within the interpretation of the criminal law here. And again, I get contacted for a letter of opinion in that regard. And sometimes I'm able to argue, especially in non-common law jurisdictions, and sometimes even in common law jurisdictions like New Zealand. I remember making a submission that their impaired driving laws and ours don't match. So if they're applying for a visa and let's say they get a PFL, so an expert opinion on the comparison between the foreign statute and the criminal code in Canada could be helpful. So it just depends on the scenario. I mean, if something comes up, you can contact me and we can go through some options during that process. So it really depends on the circumstances, but there are usually options. Right? You just have to know which pathway is appropriate and has the best chance of success. Ivy, did that answer your question?
Yeah, it did. Thank you. But this more my specific question was, there was no court proceeding, there was no report to police. It's just you and your client. You know this is an act which, if gone to court or police, could be a problem, but this is no report. What ethically you're gonna do? Are you gonna file up a rehabilitation or do explanation, or just let it go?
Right. So you mean you're saying that the client admits to you that he committed an offense, but he was never caught? Does that happen?
For instance, there was a fight between the couple and there was no report. It's there was a fight and maybe the wife was injured.
What's the criminal offense that the client fears that he may have committed? Like, did he start the fight? Like,
yeah, he punched his wife, for instance, in China. It's just a domestic deal.
Too hypothetical, because the best thing that I would advise you, if that happens, then send it out for an expert opinion to see if they match or if they're available defenses, so that you know the course of action. Right? Maybe you get an opinion that says there was no criminal offense here, right? That matches or equates to a Canadian criminal code offense. So I wouldn't just put anything down on the application, because then you could be jeopardizing the client for nothing, right? But if you get an expert who can do the equivalency exercise because the illegal act has to be illegal in the country in which it was committed, as well as in Canada, right? Right. So if you look at 36(1)(c) or 2(c), it says commits an act that is illegal in where it occurred and is equivalent to a Canadian criminal offense, an indictable offense. So before you discuss options, you really need that opinion, and that's done on a case-by-case basis.
Sounds good. Thank you.
Okay. Anybody else?
Yeah, Stephen, you mentioned you want to take a break.
Yeah.
Or we can just continue.
Yeah. Could we? And I've got
sure.
5 more people who want to come in. So let everyone get settled. I'll just I'll pause the recording and we'll see you back. Pause here. Pause. Okay, the recording is resumed.
Okay, welcome back. Yeah, thank you. Today we invite our guest speaker, Stephen Tress, an executive criminal lawyer and immigration lawyer. Stephen was called to the bar in Ontario in 1988 with 36 years of experience. Stephen represents clients in all types of immigration matters, both inside and outside of Canada, as well as appeals from various types of decisions of Citizenship and Immigration Canada, or the CBSA, to the Federal Court of Canada. And yeah, welcome back. So just now, Ivory asked some questions. If there's any other RCICs wants to make conversation with Stephen, just raise your hand by clicking the button, or Stephen, do you have, I know you are very experienced lawyer, so if you would like to introduce more like complex examples, so will be much appreciated. Thank you.
Sure. I'm just going to, we have a hand raised by Wee. I don't know if I'm pronouncing that right. Did you have a question before we'll talk
Yes.
about? Yeah.
Yes, thank you so much, Stephen, for your time. So just Ivory already asked a question related to criminal equivalency. I just want to continue with that. So normally when the client came to us, because we are not like expert in criminality matters, but we do have some kind of training or guideline for matching the equivalence of different criminals convictions between foreign countries and Canada. So what we are trying to do is we are trying to find relevant in criminal code or the federal statute in Canada to match the criminal code, to match the criminal equivalency. But my question is it always suggested for, like you mentioned that we suggest client to go for a criminal lawyer to have such a criminal equivalency like opinion. But like in what, because you are both a criminal and immigration lawyer, right? But like, do you see this a lot when like clients just come to you to have like criminal equivalency, like check something, opinion like that?
Right. Most of my initial consultations just involves doing the equivalency exercise. So I would request a certain standard list of documentation from the home country for the client to email me, and then I'll do my analysis. I mean, clients usually find me because, you know, you search criminal and immigration lawyer, criminal immigration, and I do both. And sometimes it works out well. Sometimes there is no match between the foreign statute and the Canadian statute, or sometimes there is. And if there is, or if there is a likelihood that it will be raised as an issue, then we can talk about how to proceed with a particular application. So yeah, most of the initial consultations I get are just to do the equivalency. It's not a letter of opinion or anything. It's a Zoom meeting. You know, I do my research in the background, and then I meet up with the client on Zoom, and I go through with the client my opinion on whether there's an inadmissibility issue, and if there is, then I can review the options, and the options vary depending on the circumstances. Sometimes I get contacted by an RCIC, and they want me to do the equivalency part of it, or if it's already been determined that they are inadmissible, they might want me to do the rehabilitation part, because I do a lot of rehabilitation applications. Or if it was a conviction, that only applies to conviction or a commission outside of Canada. If it's inside Canada, the rehabilitation is not available. It has to be a pardon, and I do pardon applications because I'm a criminal lawyer. So and sometimes whether it's rehabilitation or pardon, sometimes that can be done, say by me, for example, on the side, while the RCIC might be doing a sponsorship application at the same time. So what we would do is we would submit the rehabilitation application, and then the RCIC would submit a copy of that rehabilitation application with the sponsorship application. And in most cases, the rehabilitation decision comes before, you know, the 11 or 12 months it takes for the sponsorship application. So you can do them simultaneously. And by the time they're, and the visa office who's processing the sponsorship application has a copy of the rehabilitation application. So they're aware of that. Right. And there's a lot of cooperation that can be done between me and an RCIC, for example, who is dealing with a complex criminality issue. I've testified as an expert in criminal law, and actually as an expert in immigration law on a family matter as well. You know, I remember the beginning part of your question. If I'm representing a criminal client, I don't need to refer the client to an immigration lawyer, because everyone in the criminal justice system knows I also practice immigration law, so I can just talk in court, right? Or just on the phone with the Crown. But for my criminal law colleagues,
who've never done an immigration case before, they would reach out to me to do the immigration side of things. And for an RCIC who is not comfortable or doesn't feel qualified to do the the equivalency exercise, they might approach me for an opinion on that and perhaps possible options. So there are a lot of ways that a criminal lawyer can cooperate with an immigration lawyer, or an RCIC can cooperate with a criminal lawyer or an immigration lawyer. And I think it's important for all of us to work together, because these issues are important for the client, and it's important for the client to get really solid legal advice before taking any steps in the criminal case, right? Because you don't want the CBSA all of a sudden to, send a call-in notice to a client after you have told the client that no, you're not going to have any problems.
Right. Thank you.
Okay. And now we've got Jing. I think you have your hand raised as well.
Oh, yes. Hi, Stephen. It's Jing here. So I have a couple of questions. One is also, a follow-up question to my colleagues, the Hill test, equivalency test. So sometimes it's probably debatable whether that foreign crime is equivalent to any offenses under CCC. So do you just go the full range of Hill test arguments at the beginning, or you leave the heavy lifting to the IRCC and let them do the Hill test exercise and tell us that whether my client is inadmissible or what?
I never want to leave anything completely up to IRCC. You're the representative. Okay. You should make the submission up front, right? Yeah. You should do your best to, it's going to be an issue. A PFL is going to come down the pipe at some point, right?
Gotcha.
And in my practice, I'm double appearing here. In my practice, I like to beat IRCC to the punch, so to speak, and because I don't like getting PFLs. Nobody likes getting PFLs. Clients don't get PFLs. And if you think about from a client management perspective, right? I mean, this is just my opinion. I try to do as much upfront as possible, because from a client's perspective, when a PFL comes, the first thing in their mind is, how come the lawyer didn't see this coming? Right? So you don't want to be chasing issues and look like you're playing catch up all the time in front of the client. You want to make sure that you fix all the issues during the consultation, and then you offer your services based on the information that the client provides, right? And then deal with all of those issues in a submission letter, right? And if you need expert opinion, include that with the initial submission letter, right? So if a PFL ever comes up, right, make sure it is as a result of information that the client didn't tell you. Okay, because if PFL is based on information you already knew from the consultation, it doesn't make you look good in the client's face.
Gotcha. So you advise to front load the work.
Exactly. In any potential inadmissibility issue, not just criminality, right? But if you see things like there might be an issue on were they in a common law relationship for 12 months? Financial criteria, welfare issues, social assistance, previous sponsorships, possible inability to sponsor somebody because maybe they were convicted of domestic violence, or there's a waiting period. Maybe the waiting period is over. You have to address any potential wrinkles based on what the client has told you. So I have my trusty staff taking notes during the consultation, and we make sure that our initial submission letter canvases all of the issues that were raised during the consultation, so that the client knows that you're dealing with it. That's just
great
my practice advice.
That's great, thank you. And also one more question, actually two more, just bear with me, please. The New Yang case you just mentioned, do you have the citation at hand? I quickly
So you
Googled,
should-
I didn't.
You should be able to find it. I just found it the other
Okay.
day. It took me 2 seconds. You
Sure.
know what? Send me an
Okay.
email and I'll send you the link. Okay.
Okay, okay, sounds
right.
great.
Okay.
And one last thing, it's still, you know, criminality issue, but instead of being an admissibility issue, it's rather the eligibility issue. You know, under R133 1E, the sponsor in family sponsorship cases, the sponsor, if they are convicted of certain offenses, most of them.
That's what I mentioned a few minutes ago. I said, you know, the client might tell you that they have a previous, the sponsor, who's your client, might tell you that they have a previous domestic violence conviction, right? And so that there's a bar, right? So you have to, you know, you have to canvass all of that, right? And you do your submission letter. If I think it's 5 years. If the 5 years for immigration, I think 4 years for citizenship, it might be 5 as well. So if the time period has passed, right, you mention that in your submission letter, right? You have proof. You know, you get proof from the criminal courts. You got a copy of the certified court information. You got you know, you do all of your due diligence, and you put front and center that yes, this has happened, but the 5-year period has passed, right? So you want to make all of that, right?
Yes, but what if the time hasn't passed? So within that, you know, period, how to overcome the eligibility issue due to those offenses or convictions? Just wait out.
I'm pretty sure you can't, right? I mean,
just wait out.
Yeah, right. I mean, they're there for a reason, right? It's a question. Yeah. So, you know, I always like it throughout my career, whenever there have been new provisions. So like the provisions that you're talking about, I think it was like 2012 or 2014. I mean, IRPA didn't even exist before 2002, and I got called to the bar in 1988, and we had the Immigration Act of 1976. So immigration law is always changing. Sometimes the act completely changes. So what you have to do is you have to keep all of these changes in mind. You have to keep up to date with everything. And the best way, you know, I mean, there are 2 ways that I use to holistically view a new provision or a new proposal that has come up. Like when this 5-year bar came with respect to previous domestic violence convictions, you know, you have to ask yourself, because there's no jurisprudence on it, right? Yeah, there's no case law yet. It's brand new. So how are you going to approach it with the client? The best thing to do is to ask yourself, what was the motivation for the government to change this or to impose a new restriction, right? And in some cases, you know, there is a way to overcome, maybe on humanitarian grounds or a TRP or something like that, right? But when you ask yourself, the government here passed this to protect victims of domestic violence. You think they're going to do anything to you know, exempt somebody from that? Because if they, you know, you look at it from IRCC's perspective, if they say, you know, that's okay, we're going to exempt somebody from that under Section 25.1, right? And then they come. And then the new spouse gets landed, and right away the charged with domestic violence. It's not. It's going to be a huge news story that IRCC did for the 5-year bar, right? So that's how you know. I always look at what
see the philosophy behind it.
Exactly, and that's how I like to approach almost all my cases.
Okay, that's great. One last thing, I promise. The transporter criminality was, you know, nesting under one of the, you know, sub 1 or sub 2 of 836. Now it's a separate independent paragraph.
You're talking about
subsection.
ministerial relief?
No. Sorry, I jumped back to 836. And the transporter criminality was once nesting under either sub 1 or sub 2, but now sub 2.1 transporter criminality is a standing alone subsection. So what is the philosophy of this? Why they, you know, want to extract that from the old sub 1, sub 2, and make sub 2.1 the transborder criminality. The only thing I can think of is the, when people crossing the border, they don't declare certain things, or they carry certain things that they shouldn't be carrying. So would you shed some light on it?
All right. So for the specific section that you're referring to, I haven't had a file on a transborder criminality issue since they reorganized that. But what I would suggest, if you do want to know, so I'm assuming that a lot of you get a subscription to the annotated Immigration and Refugee Protection Act at Tremier's, where they have the case law. So I highly recommend that. You cannot do this without knowing what the general wisdom of the courts is. Okay. So if this came to me under the new reorganized provision, what I would do is I would compare the case law under the old section with the case law under the new section, because a lot of time the judges and counsel go into a change of philosophy. So this is why I like reviewing court decisions, because they discuss that. A lot of these cases are determined. You know how you have the objectives. What is it, Section 3 or something of IRPA, where family reunification and public safety and blah blah blah. You could even argue the ranking of like family reunification versus protection of the public from criminality, for example, and you can argue that in federal court. So there's a lot of discussion in federal court cases on the intention behind Parliament, because that is a relevant consideration when you're on a test case, for example.
Yes.
So if you're interested in knowing what the philosophical difference is, review the jurisprudence, because they would go into that.
Okay. Thank you so much, sir. Thank you.
Okay. And now we have Carrie.
Yes, so thank you, Stephen. So this is very informative. So just referring back to the very beginning that you mentioned that when people plead guilty, so they should have the right to have access to immigration consultation about the consequence. And so if somebody plead guilty without any of the knowledge and consultation, so for the immigration consequence, and later also get into issues. So my question is, if that has been happening 2 years ago, is that possible to file appeal to the criminal record and get it criminal charge and get it overturned?
Yes, it is, and we've done that several times. 2 years later, 3 years later, 5 years later, because it's when the issue becomes apparent. You see. So, and you do have to apply for an extension of time under the rules of the Court of Appeal. But depending on the circumstances, they would grant it. So let's say, for example, a person pled guilty 2 years earlier. It took 2 years for CBSA to get their act together, and then the client gets a notification. The Court of Appeal will look at, okay, so how much time passed from the time they were notified of the issue, right? Because if they're going to wait another 6 months, they may not be entertained. But if the issue comes up and it's dealt with right away, then a criminal lawyer can apply for an extension of time. And the Court of Appeal, we've done that. We've had convictions overturned that have happened years earlier. So that is possible, yes.
Okay, thank you.
If I were you, if that ever arises, I would definitely encourage you to refer the client out to a criminal lawyer.
Yeah, the criminal lawyer actually, so from their beginning, actually we have ordered
not the same criminal lawyer. Okay, that's ineffective assistance of counsel. That was the first criminal lawyer. You're appealing the first criminal lawyer's judgment. Okay, right? You go to the independent criminal lawyer for the appeal.
Yeah, so that is actually about a year ago. So I have referred the client back out to another criminal lawyer to get trying to get the charge overturned. I did not follow that up, but because I don't know whether that is possible because it has been 2 years past. But what
It's
we have,
possible.
yeah,
It's possible.
we have ordered all of the court document that's from the court of the in Saskatchewan.
Right? So follow it up with the client and the criminal lawyer and see what's going on, right?
Yeah, but it is possible to get it overturned. That's good to know. Thank you so much.
Okay. Anybody? Jack? Jack.
Oh, hi, Stephen. Good to have you here.
Thank you.
I have a question about actually James' question made me think about this, the burden of proof. So let's say I have case because I always want to choose with the lighter one. For example, I want to go for deemed rehab, not rehab. I want to go for the sentence is set maximum sentence was 7 years, not the 14 years. Let's say I have two criminal lawyers, give me two equivalency.
Where? What country? Sorry.
Let's say China. Okay, I have a
Okay. Okay. So first of all, it doesn't matter what the maximum sentence is in China. It matters what the maximum sentence is in Canada. There's no 7-year sentence.
Yes.
There's no 7 years under the criminal code. It's 5 and then goes to 10.
Okay. I want to go with the I want to have a case with 36 sub 1, not 36 sub 2. So let's say I have a client coming to me with a sentence, with a court order. I would choose criminal lawyer to do the sometimes in complicated cases, very complicated cases. I will need someone to do the equivalency exercise. I always want to go, if their opinion are different, of course, I want to go with the lighter one. Go with the criminal lawyer with opinion letter says it's a equivalency it's only Canadian, it's only under 36.
I don't know what your question is.
Okay, so my question is, if I go with, because James' question reminds me of this. So if let's say if I think this is a deemed rehab case and I go with the lighter one, I said I submit a case, I argue this person's deemed rehab. IRCC may have a different opinion. Say, okay, this is not this according to their analysis. This is
that's why we have federal court.
Yes, and my question is, who
they
has
get
the burden of proof?
They get the final say.
Yes, but do they bear the burden of proof to prove that my client is inadmissible, or do I bear the proof?
That's actually a good question. That's actually a good question. So there are two answers with two different scenarios. So one scenario is that the client is in Canada and they've been called to appear for an admissibility hearing. Okay, and the purpose of the admissibility hearing is to determine whether or not the person is admissible. The person's already here. They're not making an application for anything. They're either here as maybe a student or a worker or a permanent resident, but CBSA found out about some criminal convictions, and maybe there's a misrep involved, or definitely a criminality exercise. So in a case where the person is in Canada, they're not applying for anything, they're here already on some kind of status under IRPA, and then they go to an admissibility hearing, the burden is on the minister. Okay. Now, if a person is the opposite scenario is where a person is making an application. It could be an application. Most likely it would be an application from outside, because when they're outside, IRCC makes the determination, right? There's no admissibility hearing if the person's not here. Okay. If the person's here, and even if they're making an application, they would still go to an admissibility hearing because the IRCC would want a removal order, right? When they're outside of Canada, there's no removal order. There's just a finding from a visa officer. Now, when a person applies, the Act says that the burden of establishing that they are not inadmissible lies on the applicant. So the applicant has the burden of satisfying an officer that they are not inadmissible. That's the standard. That's the test. Okay, which is different than an admissibility hearing, where the burden is on the minister to prove reasonable grounds to believe, in most cases, at a hearing, that the person is inadmissible. So
one example I had an admissibility hearing last year, and it was a Russian client who had lots of companies and lots of businesses in Russia, and he's also here with his wife on a work permit and in the process of applying under a PNP program. And during the course of the PNP application or the permanent residence application or the work permit application, I mean, I didn't represent the client on that. They came to me after that's been submitted. During the course of that, IRCC found out about some allegations that existed in Russia about his activities in Russia. And so they issued a 44 report, which indicated that the client committed a crime. It was a commission, so it was paragraph C, 36(1)(c). They could have done it on 32(1)(c). Committed a crime over there, fraud or something, whatever it is. I don't have to get into the specifics. So they also wrote him up under organized criminality because the allegation was with respect to a company and his employees and everything else, and a misrepresentation because he didn't include, he answered no, have you ever committed anything, right? And so keep in mind, this is an admissibility hearing and the burden of proof is on the minister, okay? So then I get the disclosure, and normally the disclosure includes police reports, court dockets, court information, a prosecutor, maybe a copy of an indictment, right? But in this particular case, although I received, I think it was more than 300 pages of disclosure, it was largely newspaper articles, hearsay. There was an Interpol blue notice, which is not the same as an Interpol red notice. There was a U.S. immigration interview that took place a couple of years earlier, where the U.S. immigration officer believed that the person was inadmissible under the similar provisions in the U.S. So 300 pages, but no court documents, no docket, nothing on the justice system website. Although I think there was one person from the organization that was charged, but not him, not his wife, who was also board of directors. So they were both, this is a joint admissibility hearing with husband and wife. And all I had to do was, I mean, I didn't have to get any documents. I didn't have to try to get any court documents. That's the minister's job, right? And my whole submission was that the minister failed in its burden of proof. And I got successful finding that the client's not inadmissible. Now, during this whole 1 year process of the admissibility hearing, IRCC also put his application on hold, right? They don't make a determination if there's an IRB proceeding, because the IRB governs, right? And so since the member officially determined that the person is not inadmissible, that was enough to kickstart the application back and get it back on track, or kickstart it back and get it back on track. So even though the burden still is on the applicant to show that they are not inadmissible, the fact that they got a decision from the IRB pretty much forecloses that. But it's kind of a long answer to a short question. So if it's overseas and it's an application, the burden of proof is on the applicant to satisfy an officer that they are not inadmissible. And if the person's in Canada and subject to an admissibility hearing at the immigration division, the burden is on the minister to prove that the person is not admissible or is inadmissible. Does that help?
Yeah, that helped. And I just want to rephrase my question again. Let's say I have a rehab application. Somebody is convicted outside Canada. In this application, I need to do equivalency test, equivalence analysis. I want to go for, but either way, it's 36 sub 1 or sub 2. I need to do this application. But sometimes, in my understanding, 31 sub 1 will be easier. Let's say I use a criminal lawyer's opinion, says, okay, this crime is equivalent to a crime in Canada, which has a maximum penalty with 5 years or 7, under 10 years.
Sorry.
And
the person,
this person is outside of Canada, and are they a foreign national or are they a permanent resident?
They are foreign national.
So
Let's
you
say
should
they are
be
foreign national.
you should be looking at both subsection 1 and subsection 2, right? Subsection 2 is easier for IRCC to find somebody inadmissible because there's no 10-year or anything like that. It's any indictable offense under section 36.
Oh yes. Subsection 2, not sub 1. So sub 1 is serious criminality, sub 2 is criminality, right? So I would go choose that. I would like to choose that to go, and then
Choose it. You make your submission on the basis of
yes.
How possible
Yes.
34,
And
35, 36, 37, right?
Yes, and let's say RCC has a different opinion. Let's say they want to go forward. They want to say you are inadmissible under serious criminality. In this case, do they have the burden of proof, or do I have the burden of proof that this person is not inadmissible? In this case, in this specific case,
the applicant always has the burden of proof of satisfying an officer that they are not inadmissible under any provision of IRPA.
Okay. That answers my question. Thanks so much.
All right. I guess I better stick to the short answers.
Okay. Thanks.
You have another. Yeah. You have another question, Wee?
Yes, just continue with what Jack mentioned. I think we also had a discussion among our colleagues. So when we have a foreign national, we assess that based on his circumstances, he's deemed rehab. And when we submit application for argue for deemed rehab. But we also have a concern that if that conviction that person had in China is it might be also a serious criminality in Canada under sub. Do you think it is necessary on the side of rehab application? We also add a application for rehab.
Sorry, hold on a sec.
Okay.
Yeah. What are the two offenses that you're concerned under section 36 sub 1 and sub 2? What are the two possible choices that you're debating with that the Chinese offense is equivalent to in Canada?
So when we are doing the criminal equivalency test, I mean, this doesn't really happen, but I'm just thinking if we found two equivalency section.
Is this a hypothetical question, or is this something that you're dealing with?
It's just a client that had consultation, and we did the equivalency test, and we found two sections.
And what did you find it equivalent to? What were
122 and 128, but both are just not serious criminalities.
122 of the criminal code?
122 is breach of public breach of trust with public policy. 128 is misconduct of let me just find that.
Misconduct by a public official?
Yeah, something like that. Yeah.
Okay, and the sentences are different. One is less than 10
Actually,
years.
both of them are less than 10 years. So, but I'm just.
That's regular criminality, right?
Yes. So I'm just, I don't know. It's just have a second thought in the case when
I'm not comfortable dealing with purely hypothetical questions because it's like a consultation. I ask questions, and because it's hypothetical, you can't make the stuff up. You don't know, right? So what I would encourage you to do is if you do get a client and then there's a confusion and you want to discuss it with me, feel free to call me or shoot me an email and we can set it up and go through the specifics of a particular case. And I can give you my recommendation. If I can give you sort of a short, unofficial answer, if there's any doubt, I would do a rehabilitation application. And in the rehabilitation application, I would argue that they are not inadmissible, but alternatively, if they are, he's applying for rehabilitation.
Okay, thanks.
That's how I would approach it. Yeah.
Okay.
Right? Because you know why? Is this a sponsorship or a PR application?
It is a PR sponsorship, like PGP.
Okay, well, the reason that I would suggest
if there's any doubt, to do a rehabilitation anyway and make those two alternative arguments in the course of the rehabilitation argument, is because the time period for rehabilitation application and for a sponsorship are almost the same. And if you want to put all of your eggs in one basket in your submission letter and then not deal with rehabilitation because it's your position that the client is deemed to be rehabilitated, and if IRCC 6 months later issues you a PFL, it's going to be difficult to then file a rehabilitation application, right? Because you're already halfway through the processing. So I mean, if you got to get the client's instructions, but during the consultation, I would advise the client to do both simultaneously. Otherwise, if IRCC disagrees with the deemed rehabilitation, then your application is going to get stalled, and the sponsorship might be refused, and then you have to do the rehabilitation and the sponsorship all over again.
Yeah, so that's what I feel. It might be safer to add rehab inside.
Yeah.
Okay, thank you.
And we have Ivory again. Ivory, you have your hand up or no?
Oh, sorry. No, I didn't have a question. Yeah, sorry about that.
All right. So there's some more people in the waiting room here. Emma, I don't know what you want to do. It's almost 2 p.m. What did you want to do?
Yeah, thank you, Stephen, to bring us very insightful conversation and seminar. Is there anything you want to cover? But we still have a couple of minutes if you want to, give us some more.
My last minute advice is, especially when it comes to complex cases, is I mean, when I was starting out, I networked with back then, of course, back in the 80s, there were no consultants or licensed consultants anyway. I got involved in groups like the one that you have, and there were a lot of senior colleagues of mine that belonged to the group. And if I had any questions, I'd either pick up the phone or shoot them an email or something and see what their take is on that. So if there's a criminality issue, or if there's a complex admissibility issue, I would encourage you, if you know an experienced immigration lawyer, I mean, you guys are always welcome to contact me, but if you already have a contact, you already have a connection, I advise you to get some feedback, because even with my years of experience, once in a while, I contact my colleagues, some of whom I went to law school with, who have been practicing as long as I have, and I say, listen, I got a client, it's kind of interesting, I think I could go either way. What do you think? What would you do? We chat about these, like you guys have your WeChat groups, and I'm still old school, so we still pick up the phone. But my final comments is, don't be afraid to seek out the advice of someone who's more experienced, who may have dealt with these issues in one form or another.
Okay, so would you mind to share your contact information so I can,
It's on my website, which is stephentress.com.
Oh, okay, great. So I can, bring
the
contact information into our WeChat group.
Name.com. Easy to remember.
Great. Okay. Yeah, thank you, Stephen, helping us understand the various aspects on the intersection of criminal and immigration law in Canada. We appreciate you for taking time for this seminar and sharing invaluable advice. Once again, thank you. And
it's a pleasure, and I really appreciate the invitation, and I hope it was helpful and useful to everybody.
Yes, sure.
Okay.
Right. So, we will share your contact information. I will put into our WeChat group. So anyone who wants to consult or email you, they can just do that by refer this information.
Great. Nice meeting everybody. Good luck.
Thank you.
Bye.
Bye.